that he must seek to narrow his world and wall in a space such as fitted him. He was at first bare and out of doors, but though this was pleasant enough in serene and warm weather, by daylight, the rainy season and the winter, to say nothing of the torrid sun, would perhaps have nipped his race in the bud, if he had not made haste to clothe himself with the shelter of a house. Adam and Eve, according to the fable, wore the bower before other clothes. Man wanted a home, a place of warmth or comfort, first of physical warmth, then the warmth of the affections. Well, those kindly words are from Walden by Henry David Thoreau, about, of course, his time on Walden Pond in his little cabin. We're going to have a case today about a few other little cabins, mini cabins, and whether they constitute houses that are protected by the Constitution, just like we would think Henry David Thoreau's was. We're doing that in an episode about the Sixth Circuit, because that case is from the Sixth Circuit, and so are others we will be discussing, and so are the lawyers who are on this show this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, August 14th, 2025. And yes, we have a couple special guests this week who are discussing the Sixth Circuit. Now, it's a little serendipitous that we're doing this right now because in just a couple days from when I'm recording this, we're going to record an episode about the Seventh Circuit that will be out later this month, and that is our Short Circuit Live in Chicago. If you're listening to this right after the episode comes out, you can still come. It is August 17th. That's a Sunday at 7 p.m. at the Swiss Hotel in downtown Chicago. So hope to see some of you there. And we'll talk all about the Seventh Circuit then. But this week, it's the Sixth Circuit. And this all came together because recently I was invited, very kindly, to a debate about universal injunctions, which, of course, is an issue that my side did not come out very strong on at the Supreme Court recently, but still, it was a fun debate. And that was in Detroit, and I was invited to do that by the Michigan chapter of the Lawyers chapter of the Federal Society. And I was invited to come by two young lawyers who I was very impressed by. And I said, well, you guys should come on the show. And they are here with me today. They are David Porter and Sean Dutton. Now, I'll introduce them, and then we're going to talk a little Sixth Circuit talk. Both of them clerked on the Sixth Circuit. They both practice there. They know all kinds of Sixth Circuit stuff. And then we will get to those cases. So we have this Fourth Amendment case about cabins, mini cabins. And then we have a case about prisoner rights and the interests that prisoners have when they're already incarcerated. And then we're going to end with a little bit, as some say, a little bit of candy about some en banc sniping at the Sixth Circuit that just happened the other day. So first, these two gentlemen. They are David Porter. He is a partner. Now, he is a partner at this firm. Both of them work at this firm. I'm only going to say the firm's name once. It is, because I know I'm going to pronounce some names wrong. It is Keenbaum, Hardy, Viviano, Pelton, and Forrest. And they can correct me if any of that was wrong. So David was a graduate of DePaul University College of Law and also an undergraduate at Michigan State. So he's a Spartan. He clerked for Judge Richard Griffin on the Sixth Circuit and also for Justice David Viviano of the Michigan Supreme Court. Meanwhile, we have Sean. Sean Dutton is an attorney at the same firm. He is also a graduate of DePaul University College of Law, but he was an undergraduate grad of the University of Michigan. So we have a Wolverine. I'm not going to play favorites between Michigan State and Michigan on this show. I will say that the University of Michigan has an excellent press, which releases some excellent books, including one that just happens to have been written by me, came out a couple years ago. Moving on. Then Sean clerked for Judge Richard Griffin on the same judge for the Sixth Circuit, and also for Chief Justice Robert Young and Justice Curtis Wilder of the Michigan Supreme Court. So he's a triple clerkship kind of guy. So David and Sean, welcome to Short Circuit. Please tell us all you want to about yourselves, including where you work and what you do.
Well, thank you for having us, Anthony. As you said, we're attorneys here at Kienbaum Hardy. We focus primarily on appellate law. We're a boutique appellate firm, also do a little bit of labor and employment work, and as many pro bono civil rights cases as we can get our hands on. And we're happy to be here today.
As much as the billing will allow, some may say.
That's what he means by get our hands on. Absolutely. Yeah. So I'm Sean Dutton. Thank you. Yeah. The triple clerkship thing, actually, if you ask Bob Young, he would describe that as refusing to grow up. And so eventually I got done with those and moved on to practice. But I'm also excited to be here. I joined the firm somewhat recently, and David and I are really excited to keep building up this appellate practice. And this nerdy niche of federal intermediate court decisions podcast is right dead center bullseye for us. So we love this. Thank you, Anthony.
Well, we're happy to have you. And you said it was time that your judge said it was time to grow up. I clerked with a fella who called himself a traveling clerk, and he had clerked in West Virginia, and then he clerked in Montana, and then he had a clerkship in California. And, I think there's this subset, like this culture of people. You hear about, fancy clerkships. Like I had 2 on the Fifth Circuit, and then I Supreme Court, and then I had another one. But I think there's also this level of people who's just like clerking, and they, whatever court it is, they'll just keep moving and clerking, and kind of like, a nomad of old. But I'm glad that you guys have given up that lifestyle. You're a little more sedentary now, and you're in the Sixth Circuit, which is what we wanted to take a part of. So I should explain. We always throw around on Short Circuit the circuits, like the Ninth Circuit. It has this thing. The Fifth Circuit, of course, is a whole different kettle of fish. But we often don't mention what that really means. So I'm going to just set the stage real quickly right now, and this will then go into David's case, which is a very regional specific case. So the Seventh Circuit, which we'll be talking about next week, is actually small as the number of states. It covers Illinois, Wisconsin, and Indiana. Right next door is the Sixth Circuit, which is Michigan, Ohio, Kentucky, and Tennessee. So not that many states, but there's some big states, and they cover a lot of area. And then within that area is a lot of room, especially in Michigan, for trespassing. Now, David, you're going to discuss this case which has to do with trespassing, Fourth Amendment, and all that. But at the very beginning, I was trying to look up where the property is, where this took place. And am I right? It's kind of like northern Michigan, so not the UP, but kind of north up on the Hand, if you guys know the Michigan Hand, but kind of towards Lake Huron, like the east side. Is that right?
That's right. Yeah. So if you use the hand as the map, it's where the base of the middle finger and the pointer finger meet. Is where I would describe it. Yeah.
I'm glad you have it mapped out to that degree.
Yeah. Yeah, and so it's up there, and it's where people look for property when they want to get away from the hustle and bustle of Southeast Michigan, and I'm sure something similar where you're from in the Seventh Circuit. People want to leave Chicago and go up north to Wisconsin, things like that, and people want to. It's like Thoreau's Walden. They want to get away from it all and just be secluded, and which is sort of the interesting context for this case. And how it starts is, why these officials made this uninvited visit to do some code compliance checks. So,
real quick, as an aside, sort of a regional dialectical thing. David actually just very casually used a phrase that we in Michigan use constantly, which is like, "What are you doing this weekend?" "Oh, I'm going up north." Going up north it means I'm going to a cabin or a lake house, and it just means up north because most of our population lives in the Metro Detroit area, and so it's sort of the out counties further north along, state and national forests and all this stuff. People tend to buy property and have a second small place where they can get away.
And it's the same in Minnesota. You might say outstate, But often in Minnesota, if you're going to the cabin, it's up north. But it could be up north of Wisconsin, Minnesota, where it could be in Canada. Even some people have cabins, but it's that way.
Culturally, Minnesota, Wisconsin, and Michigan have some similarities in that, I think.
Oh yeah, yeah. They're all part of the Yankee Empire.
That's right. Yeah.
Yeah. So the Mockridge case, this recently decided, but it started about 2020 when the Mockridge family decided to buy their cottage, their cabin up north. And just as a little context, when people buy their cottage up north, a lot of times they'll mark their property. Anybody who's traveled up north down, US 23 or any of these smaller highways, you'll see dotted along the roads, the sign that they put up sort of marking which one is theirs. And some of them just say the Porters or the Duttons, but some of them get a little funny and they'll say it's the Porter compound, things like that. The reason why I bring that up is because the Mockridges made a similar decision when they bought their cabins. And it sort of gave rise to this case that we're talking about here today, 5 years later. When they bought the cottage, according to the papers that I read in the case, the family was split. The parents really wanted to get a place down in Key West, down in Florida, but the kids really wanted a place up north. And that's, in Michigan, that's the perennial, choice that you need to make. Are we going to go down and be snowbirds down in Florida, or are we going to get a place up north? Things like that. And ultimately the kids won out and they got a place, found a place up in northern Michigan. And so they decided as a joke to put a sign out in front of the property that says Key West National Forest, the Mockridge family compound. And this sign, if anybody can sort of visualize what a standard national forest sign looks like, it's the same trade dress as you would see if you go to any national forest sign, I assume. And so it looks genuine, but it's a riff. It's a parody.
I'm looking at it right now. David shared it with me before the show, and I legitimately was confused. I was like, but that's in Florida. I didn't notice at the very bottom it says Mockridge family compound. So it is, a spitting image of a real. It's probably some kind of trademark infringement on the federal government, but we won't get into that.
So, anyways, that's the sign that sort of gave rise to this whole case, because where they bought their property, it is surrounded by what I would consider to be what it seems to be one owner, and that owner sees this sign, thinks that there's a campground going up, and he calls out a couple of local officials to come take a look to see, hey, are they following all the local rules in terms of having a campground? When they get there, they set up the site visit. When they get there, they see a normal house-looking cabin, but dotted around the cabin are five or six mini cabins that have recently been put up after they bought this property. And the court opinion actually goes into some detail about what these cabins look like. And I think that's important, so I'll just list it off. Each has a bed, a closet, it has outlets, no plumbing, but it's got an insulated roof, it's got solid walls, a porch, and some windows. And when these officials come out to take a look, they first go up the driveway, and that's where they see this sign. And so this sign is not visible to the public. It's only visible to somebody who actually comes up their driveway. And when I say driveway, I'm stretching the meaning of that term, because really what it is, it's a trail. That the only reason why you would be on this trail is to go to this portion of the land. It is on their private property, and it's very difficult. You would never be on this trail unless you were going to the Mockridges.
So you can't bring a four-wheeler or a car up it.
Exactly, unless you were going to their campground or their cabin.
Okay.
So the idea that you see this sign and think, oh, there's a campground here, I'm a little skeptical that was a fair inference, but we can get into that later. So they drive up the trail, they see the sign, but then they don't keep going. They don't go to the house and they don't go knock on the front door. They turn around and they go to the adjoining landowner's property, sort of go the long way around, and they walk through the woods. And it's uncleared, dense forest. And anybody who's ever been up north in Michigan or maybe anywhere else that doesn't have cleared land, It's not easy, and it's not something that you would typically do, especially when you have a trail that leads right to your front door. But nonetheless, they traipse through the forest and they come upon the cabins, which are sort of near the property line, and they enter the property and start taking a look and doing visual inspections around the 5 cabins, taking a look inside. They take photos, they take measurements from where the cabins are vis-a-vis the property line. And then they leave and send a letter a few days later saying, we've determined that you're starting to build a campground here. It's unlicensed. You don't have any permits for any of this. So you need to stop work immediately and start undergoing that process. And that immediately spawned a lawsuit from the Mockridges, who I think quite reasonably at this point think they're being picked on. And it eventually culminates in some cross motions for summary judgment by both sides, with the local officials. One's a building inspector, the other is the local sanitarian, one's a property assessor. They move for qualified immunity, saying, look, even if this was a Fourth Amendment violation, we're entitled to qualified immunity, either because we didn't violate the Fourth Amendment at all, or it wasn't clearly established that what we were doing was unconstitutional.
And they don't sue the neighbor, right? Like they don't bring the neighbor in on some kind of conspiracy claim.
They do sue the neighbor, yes. And
they do?
They do sue the neighbor. He was included in the original lawsuit, but he was dismissed from the lawsuit as part of this ruling, and I don't think that was appealed.
I see.
Yeah.
Okay.
So on cross motions for summary judgment, the district court looks at this and says, well, this is a Fourth Amendment violation, and you're not entitled to qualified immunity. And the local officials, he leaves the question of damages, and there's another claim in the case that we won't talk about. But it's not a final ruling. But the officials press ahead with an appeal to the Sixth Circuit, which they're allowed to do. You're allowed to appeal a qualified immunity ruling before final judgment, but you have to accept the facts that the plaintiff is alleging or has established is true. And that is usually, if you do this kind of law, you realize that that's one of the sticking points on appeal is, has the defendant really truly accepted all the facts? And they do address that in this case. And they conclude that yes, the defendants are accepting the facts as true. What we're here to decide is, what is the legal significance of these facts, the facts that I've already explained. And really the question comes down to, is this a search? And if so, is there any case out there that would have clearly communicated to these officials that what you're doing is unconstitutional? And again, the claim was a Fourth Amendment claim. So as listeners may or may not know, there are 2 ways now to go about examining whether this is a violation of the Fourth Amendment. If you went to law school when I did, the question is okay, did you have a reasonable expectation of privacy in the area that's being searched? Now, I think after Jones and some other cases, there's an alternative framework. It's the property-based approach. And the question is, did you physically intrude on a constitutionally protected area? And if so, were you doing so to obtain information, to conduct a search, whatever that may be? And there was really no discussion of the reasonable expectation of privacy approach. The court just said, we're going to do this under the property-based approach, and there doesn't seem to be any disagreement about that between the parties. And once you put it in that framework, this seemed like a pretty straightforward case to me. You have cabins, you have units, dwellings that look like people live there. And in fact, the whole impetus for the site inspection was, hey, we think that you're inviting people on the land to dwell in these little units for maybe not an extended period of time, but for a short period of time. So
right, for at least enough time the Fourth Amendment would apply.
Exactly, yes. And the opinion has the typical flowery language about the home being the core protection of the Fourth Amendment. It protects the most frail cottage, which, it may be dicta, but it applies, I think, directly to the facts of this case. And it pointed out that it even applies to something like your house up north that you may not have the homestead exemption for. It may not be your primary dwelling, but it is a place that you go to seek refuge, as you noted at the outset of at the podcast. And so the court was like, this is clearly protected by the Fourth Amendment. It was so straightforward that I was sort of scratching my head as to what would be the counter argument to this. How did the defendants sort of look at this? And it was interesting. They didn't attack whether or not the cabins were protected by the Fourth Amendment. They focused on the bigger unit, the home that was on the property, and they conceded that was protected by the Fourth Amendment. But then they asked, okay, well, are these cabins within the curtilage of that home? And the curtilage just means the buffer zone around a dwelling that if people who do Fourth Amendment are quite familiar with, but it's that area that is near your home that needs to be protected, because if not, then there would be nothing to stop the government from coming right up to the threshold.
Right. But if you go beyond that curtilage, but you're still on the property, then that's considered an open field, quote unquote, even if it's woods. And that's not protected by the Fourth Amendment.
Exactly. And that's what they invoke. They invoke the open fields doctrine, which I thought was, as a matter of doctrine, would probably be okay. But I thought it was ironic because you just traipsed through, I don't know, a half a mile of dense forest.
It's not a field.
Exactly. It's an open field, but only in the weakest sense of the term. But I grant that that's, if I were on that side, I think that would be the way to argue it. But they didn't really address, well, what about the cabins themselves? And that's why I think the court went to such great lengths to describe in detail what these cottages are made of, because they really are mini homes that they were putting up.
Real quick aside, David, the one thing that's made me think of, the mini home thing, and I don't want to equate the two, because I'm sure these are very nice, well-built, like mini homes, cabins, as we see has become sort of a trend these days. But I remember there being some sort of an issue even back with like the Unabomber, with his like hut in the Montana forest, and there were some concerns about the Fourth Amendment validity of that case, and so they were kind of glad that he pled out a little bit. And if the Unabomber's shack with like no electricity and water had Fourth Amendment concerns, I have a very hard time seeing how even the smallest new modern mini cabin can't fall within that protection. So I agree with you. This seems a little bit obvious. If you start looking at the facts of this.
Yeah. Luckily, we avoided some bad facts make bad law type situation with that case, it sounds like.
It is. So I was really struck reading it by how many adjectives and facts they gave to these little mini cabins. So, the interesting thing about that reading I had from Thoreau is it's in the middle of a discussion about what do you need for a home? And of course, he was like, you can have this big fancy house, but you don't really need that to be happy. So he has this basic little cabin. But he also talks about like the Native Americans, some of them just stay in a wigwam, and that's a home for them, and they can afford it. They don't need to rent like a lot of people in his day and age, because it doesn't cost a lot of money. Well, that raises what is really a home, what's a house? Like the Fourth Amendment talks about houses. And so, although they don't get into it, it seems like in the back of the court's mind is like, the more we can make these structures like your stereotypical single family homesteaded home, kind of the closer we get, it's not that like it's a building and you can sleep in it. Right. And, or even maybe not sleep in it. Like, it says houses, a warehouse has Fourth Amendment protection. Hopefully no one sleeps in a warehouse, at least if they don't have to. And so one other point on that is they cite this case Dunn from 1988 that has these factors about they only cite it once. It looks like that's about what constitutes curtilage and, how you do this analysis. And I completely agree with where the court came out, but Dunn is not a great case for Fourth Amendment advocates. Dunn is about a barn, and the cops in Dunn, where they find what they did was okay, they go right up to the window. I think they might even shine a flashlight like in the window to look for meth operations, basically, or whatever it was. And so the question has been open for a long time, that it's not the actual house of a residence, but an outbuilding. Does it have curtilage? How much curtilage? Does it depend if someone's living there? And these are all like super open questions. And the court here, maybe wisely, like it doesn't really go into that. It's just like, these basically look like real homes. So we're just going to say if you're in the curtilage of these real homes, which they definitely were, whatever curtilage is, then it's a Fourth Amendment violation.
Right. Yeah, and I don't know if this was a strategic choice by the plaintiffs early on in the case to make every effort to show that each one of these cabins is an individual home, because then that sort of changes the focus of the analysis. And if so, then the court was easily able to follow that line of reasoning and reach the result that it did in this case. You could easily see another case where it's not litigated that way, where the focus is on the actual home itself, and now the parties are disputing the pole barn from Dunn and whether that has curtilage or not, if it's not, quote, a protected space for the Fourth Amendment. So if that was a conscious choice by the plaintiffs in this case, I mean, kudos to them. But either way, I think the court came out correctly in looking at each one of these. And I also agree, by going into such factual detail, I think they took this case out of being one of those sort of boundary pushing cases. You won't be able to look at this case and say this is the outermost bounds. It's the frail cottage. It really is not. I mean, these had beds. It had windows. It had electricity. It is a, quote, mini home.
Right. Although it didn't have permanent residence. I guess that's the one.
Yep.
Asterisk to all that. So I think you're right, and it kind of can't be at the boundary, right? Because it's qualified immunity we're talking about, not just a Fourth Amendment violation.
They then went on to say, well, are you searching? Because you just visited the site. And one of the arguments from the defendant in the case was, I went there, but I didn't do any searching. I just was on the property. I was there in a sort of a support role.
I just got lost in the woods, I guess.
Something close to that. But it was very clear that they were there searching for information. And the only reason why I point that out is because it is sort of an extension, or it's a carry on from this new Jones approach, which is, I think it was always there under the other framework, but is really sort of articulates specifically, well, what is a search? You're there for information in one form or fashion. And they were there, obviously, for some information. They had a complaint about code violations, and they were there taking measurements, taking photos, looking into the windows. They weren't just there for a social visit. And I think that's a key aspect of the case, because it was one of the defendant's arguments that, hey, I was just there, I was in support role, I wasn't actually doing any measuring or anything like that.
Well, overall, definitely it's a search. And it's hard to imagine they'd be for any purpose other than information, which is what they did with that information when they said there was building code violations. Well, so that was about one type of home. Another type of home that we all hope we never reside in is a prison. And so Sean's going to talk about a guy who's been in prison for a long time. But just because you're in prison doesn't mean you don't have any rights at all. And so it's about kind of where those boundaries lie for someone in that situation.
Yeah, absolutely. So my case is McClendon L. v. Washington. This was issued a few weeks back by the Sixth Circuit on July 21st. The plaintiff, Anthony McClendon, is, by all accounts, a very troubled individual who's made some very big mistakes in his life. He has been incarcerated since the mid-'80s and originally pleaded guilty to third-degree criminal sexual conduct in 1986, but completed that sentence by 1999. However, he stayed in prison this entire time because he was also convicted of a second-degree murder conviction. Then, while in prison, he picked up an additional conviction for assaulting a female corrections officer. I believe he claimed that they were in some sort of consensual sexual relationship, but I find that hard to believe as well. And the court doesn't really dive much into that. As relevant here, because of his original sex offense conviction, a prison healthcare official, quote unquote, recommended that McClendon complete Michigan's sexual abuse prevention program in 2017. He twice began that program, but was removed because of, I think, misbehavior and failure to comply with the requirements. And since then, he has just outright refused to participate or re-engage with the program. And because of that failure and refusal, he's been repeatedly denied parole. Now, the opinion doesn't dive in very much, but I think it's pretty much directly, well, this is a 12b6 dismissal. And,
So, motion to dismiss resting on his complaint.
Yep. And so I think the allegation there is that the denial of parole is directly because of his failure to complete this program. So he sued under Section 1983, arguing that requiring him to complete the program as a condition of parole and treating him as a sex offender without a separate hearing violated his due process rights under the 14th Amendment. Now, the Sixth Circuit began this question the way a lot of them do by asking, what's the protected liberty interest you're arguing about here? As your listeners are surely aware, the Due Process Clause protects certain inherent liberties like freedom from physical restraint, as well as rights created by state law. But, the court explained, a recommendation to participate in a prison program is not an atypical and significant hardship. It's part of the ordinary incidents of prison life. And the sex offender label, while itself creates a stigma alone is not enough, and there has to be a something more plus the stigma to find a liberty interest. Beyond that point, the court, made several other things. They kind of went bang, bang, bang through his arguments and knocked them down one by one. The court noted that Michigan's parole system is entirely discretionary, which means they have no state-created liberty interest in obtaining parole. It's entirely up to the parole board, and the court just does not review that. That's something I've seen dealt with in a bunch of other cases. Rick Wersha, White Boy Rick, who was pretty famous in Michigan at least, a former cocaine dealer back in the 80s. He has, litigated his denial of parole for years and years and years until he was eventually released. And they've continually reaffirmed this principle that it's fully discretionary.
It's an interesting incentive there that if the government makes something completely discretionary, then they don't, have to worry about due process. But if they actually put a set policy in place, then they can be held to it. Which I'm sure there's reasons on the one side why the court looks at it that way, but it's interesting that then the state is probably going to set it up that way because then it won't have to worry about those restrictions.
Absolutely, and Anthony, I'm sure you and your colleagues at IJ are well aware there are countless ways the government can sort of inoculate itself from review of its
Right.
decisions, and that's probably a constant problem you all face in litigating for your clients. And this is another one, and it's in the prison context, and there's not a lot of political ammunition to try to change these rules to make it more favorable for the guy who's serving life without parole,
Right.
or life with possibly parole for murder. The court also noted here, by the way, that every federal circuit to address this issue has agreed that a prior sex offense conviction allows prison officials to require sex offender treatment as a parole condition without additional process. Like that conviction alone just makes you a sex offender eligible for this process. Now, I think that's important. I think that's probably, that's almost enough of a kill shot for his claim. And, because he pleaded guilty to that in 1986, he could have contested it and tried to fight that. But because he didn't, in the eyes of the law, he is a sex offender. And so, he gets this mandatory, well, not mandatory, sorry, recommended treatment. At base, this case matters because it does dig into sort of what counts as a liberty interest, and how courts separate what is everyday prison life, which no one loves or would aspire to live through, and truly onerous conditions that require just an additional process before they can be imposed. But beyond that, there's actually 2 points to consider that I found interesting in this opinion that I'd like to discuss if possible. So first, and this is more merits based, it initially piqued my interest because of one paragraph in the opinion where the court talked about the program he refused to participate in. In my first read through the decision, I noticed that the court specifically characterized McClendon's participation in the sex offender program as a mere recommendation by a prison healthcare official early on in the background. The analysis then relies on this descriptor as part of its rejection of his claims. In one paragraph, the court says that McClendon's complaint does not allege that Michigan administrators required him to participate in this program, unlike a similar program in another state. before noting that rather, the complaint alleges that they recommended he participate and that he has refused to follow this recommendation. The court went on to explain that without more, McClendon does not have a liberty interest in avoiding a mere official recommendation, what essentially looks like government speech. Because unlike a command to go to a mental hospital, a recommendation to participate in a prison sex offender program falls within the range of conditions of confinement to which a prison sentence subjects an individual. On this point, the court discussed a case called Renchensky v. Williams from the Third Circuit in 2010 with a CF site, presumably distinguishing the case with sort of a back of the hand. Renchensky was interesting. I looked into this, and in that case, Renchensky had been convicted of first-degree murder, but was later classified by the Pennsylvania Department of Corrections as a sex offender, despite never being charged with or convicted of a sex offense, and then was enrolled in Pennsylvania's sex offender treatment program. In that program, the court held that the Pennsylvania program, in that opinion, the court held that the Pennsylvania program was mandatory, not recommended. And so the coupling of, quote, the stigmatizing consequences of being labeled a sex offender with mandated behavioral modification therapy constitutes the kind of deprivation of liberty that requires procedural protections. Now, the reason I point out this paragraph citing Renchensky is because I question the court's sort of back of the hand distinction of this a little bit. Now, the point about Renchensky never having been convicted or even charged with a sex offense and then being declared a sex offender by the state, that seems to me to be a very strange point, and the government should have to back that up a bit. But the court didn't seem to rely on that. They relied on the second point, which is that in Renchensky, the court held that the program was mandatory. And here, again, they say, McClendon does not have a liberty interest in avoiding a mere official recommendation, what essentially looks like government speech. Now, characterizing them sending him to the Michigan sex offender treatment program as a recommendation, I think is a little bit disingenuous. Again, his failure to comply with that program, what can they do? They can't throw him in prison. He's in prison. Maybe they can take away TV time or maybe put him in, solitary confinement, but that's not really the sort of thing, that you think would follow from failure to take a program. That's more of like, misbehavior with other prisoners. So denying him parole, to me, really makes this seem, not quite like it, but essentially a Hobson's choice. Like, do it or stay in prison. And there's really only one choice there if you're being reasonable. Now, obviously, there isn't because he refuses to do it and he remains in prison. But to me, it feels sufficiently coercive that I'm not sure this is just a recommendation. And I understand this is at the complaint stage and maybe that's how he pled it and maybe he shouldn't have pled it that way. But it just...
Well, he says, and as a practical matter, right, like you have to. They never let anyone on parole unless you do this. So, I mean, de facto, it is required. Yeah,
exactly. This is sort of a de facto, I think, mandate because otherwise, he will die in prison, and I'm not sure that's an equivalent choice, and that's sort of my take on that. So,
I mean, that sounds like a liberty interest.
Yeah, and so I just think that the CF site to Renchensky. There, I think maybe the court could have dived in a little further on that, but again, I understand that it may not have been ultimately dispositive because of some other things they talk about. Again, they kind of knock his claims out one by one, so I'm not sure he has many legs to stand on. I just wasn't sure that one was knocked out as quickly as they did. Now, my second point about this opinion is a little bit more, esoteric or niche. Hopefully your listeners will forgive me because this is pretty nerdy even in the context, like I said, of a podcast about federal intermediate court decisions. But this is
you're not going to out niche and out nerd us. Okay. Give it a try. Yeah, we'll see.
So this is purely beyond the merits. I just thought that the writing style of the opinion was interesting. So I think Judge Murphy, who I believe is a former Kennedy clerk and SG of Ohio, so a highly accomplished writer. And one who I think is a great writer. I just found this opinion to be really, really embracing, like the new school of legal writing, plain language and all of that. I don't know if you want to call it like avant-garde, but the stuff that's been discussed sort of ad nauseum by the Guberman types and those folks. Um, for example, his facts section, and I understand, again, it's based on the complaint, and so he's not going to dive into sort of contested facts and things like that, but it's very short in plain language. It's like just over a page. It consists almost entirely of paragraphs of 3 sentences or less. It's just very, very punchy and to the point. And I think most notably to me was his routine use of almost a call and response style. So he is continually asking questions and then answering them, almost as if he's having a dialogue with a hypothetical reader, what they might ask next. In discussing the relevant case law, he asks, so do prisoners have any liberty interests left? And then immediately provides a short answer, yes, a conviction does not extinguish all of their constitutionally protected liberty, before going further into the minutia of this point. In another paragraph, he poses the question, what must a state regulation contain to create this liberty interest? And then he explains that. Later, when applying the legal principles to McClendon's case, he asks, do these allegations establish the deprivation of any sort of liberty interest? But before providing the reader with a clean conclusion, we answer no. Again, he then, after noting that McClendon must identify something more to allege a cognizable liberty interest, he poses a question to himself. What is McClendon's something more? And finally, and this might be the most sort of colloquial version of this, in rejecting a counter-argument by McClendon, he notes that McClendon argues that he has an interest in avoiding sex offender treatment grounded in the plain meaning of the word liberty, before retorting simply, why? Which that's a very sort of dismissive way of going about it. But I think it's very easy to read and understand.
So let me ask you on that. A lot of the pitfalls of this approach to legal writing, which I agree with you, I think is a breath of fresh air. One of the pitfalls is being a little too easygoing or
glib?
Dismissive, or glib is a good word, especially in cases like this where you have somebody's actual liberty at stake. And so this last one, I think, is what this last example that you gave caught my eye. In an otherwise, I thought, very respectful tone. It was conversational, but it didn't take the matter too lightly, and it engaged with the legal. But this last one, I thought, that might be a little too glib. What are your thoughts on that, and where do you think the boundary is in terms of being too conversational and losing that judicial air?
I'm sure Anthony has thoughts as well. I'm sure most people listening to this have thought about this issue and have come down on it one way or the other. I agree with you. I think the last example was sort of the furthest. I'm not sure if it crossed the line or not. I think that in this very short 10-page opinion, where, again, Judge Murphy addressed a bunch of sort of subparts to this claim by McClendon, this call and response approach is very effective. It's punchy. It keeps the reader engaged. I think, I don't know that I would have done the last one, but I don't know that it's so out of bounds that people could say, oh, this was disrespectful to the litigants. I mean, again, there's a range of reasonable outcomes sort of situation here, and I think this falls within it. So no abuse of discretion by Judge Murphy.
Affirm.
I think you're talking about kind of two different things there that weave together. One is the ease of writing and making the writing effective. And that call, I hadn't thought of it as a call and response, but it is very educational. Like, I found reading this opinion, I learned things that maybe I kind of read those cases before, but I hadn't thought about it in that way. So in that way, it was well done. But then, going kind of to the point of glibness or dismissiveness, where because you don't think much of the claim, you don't fill in all the dots, all the blanks. And so there's a little bit of yada, yada, yada there. And so the reader gets the sense that, oh, okay, well, I guess there's not much to this claim. And, that can be done, especially when a litigant's making semi-frivolous arguments that the judge will just say, judge will say that there's nothing here. But especially when you have someone in this situation who this is not a totally frivolous, prisoner lawsuit. This guy has an argument. Mm-hmm. I think you want to be a little bit more careful there. It's different when, we've talked about on the show many times before about, say, the use of pop culture references in legal writing. And those, and I think sometimes judges and more probably clerks get carried away with importing that in. But that's usually, you see it come up on like cases about, I don't know, trademarks or where there's corporations on either side. So they're like, these guys can take it. I'll just write. But when you're dealing with a prisoner with a real beef, I think you want to be a little bit more circumspect.
So on that note, just to go back to the merits, because I agree with you. I think there is sort of fundamentally, there is some grievance here. I think that he has, but I think, is torn between these two claims that I think independently would fail if it was just your garden variety claim. He can't challenge the denial of his parole because that's ultimately a discretionary decision, and I think prison officials would be able to get rid of that case quite easily. And you look at it just as the participation in this program, again, it's just a recommendation. No one's forcing him to do it. And so if you look at it, if you sort of separate it out, it's easy to see how the court gets to this conclusion. But he doesn't live in those two separate places. He lives in the overlap between the two. And he doesn't want to participate in this for whatever reason, but he also wants to be granted parole because he thinks he's otherwise qualified for it. So I guess the question is how do you, if you're in this person's position, or maybe these other types of cases where you have these established legal doctrines that give you a clear answer and the answer is no for whatever relief you want, how do you sort of navigate those or meld them together? I thought maybe the other case is not a good example of this, but they were able to navigate what could have been some dicey legal landscape with the definition of what a home is or what's curtilage. They were able to sort of navigate that, but unlike in that case, Mr. McClendon was not able to. How does that look like, and what would have been for him in this case? How would he have gotten to a yes here? I don't know. But it seems like he should.
I think it's tough. I think you're right. I think the answer is probably no stacked on top of a no, and so he just gets a no. There's also another interesting little aspect of this, which I mentioned in discussing the facts, but didn't as much in the analysis because they kind of didn't talk about it either. Now, he did finish serving his sentence for sexual assault in 1999, and he was ordered to do this sexual offender program in 2017, 18 years later. And he makes the point that, I've done my sentence for that. I shouldn't have to do this. Now, that's a tough uphill climb too. I mean, we have these, SORAs and all of those sort of acts all over the country that have largely been upheld. So,
where you're basically you're labeled a sex offender for life, no matter how short your sentence was.
But he makes a point that he's seeking parole for a murder. He's already served a full sentence for sexual assault, and he's not getting parole for his murder because of something related to a completely finished sentence. And there's something there too. I don't know that it's enough to get you over the hump, but there are enough of these, I don't know what to refer to other than like a aspects of this case where you think there's maybe not enough to win, but there's something there. And to your point about, the punchiness or sort of papering over an argument, what's interesting is, this is a published opinion, obviously. This isn't like a mem dispo on the Ninth Circuit where they, keep it to under 5 pages and just sort of like say the argument and then say no with a citation to some opinion from 1992. So, I think that's part of the discussion we had moments ago where you said, it's interesting how much information do you give to allow the reader to agree with you, or do they walk away going, maybe there's more there. And a 10-page published opinion is not uncommon in the Sixth, especially with, a 1983 claim. But it does feel like there could have been maybe a couple more paragraphs on some of these things just to really button it up. Because, again, I think the result is probably correct. But there is enough of a, like David said, sort of the middle of the Venn diagram here where he sits is unique enough that we should, really color that whole Venn diagram circle in to make sure we got it all covered. I don't know how else to put that, but I just thought it was interesting. The writing style I thought was effective, but maybe left some questions if you had them.
I will say some of the clearness of the writing reminded me of another Sixth Circuit judge, and that's Judge Sutton, who even when I disagree, I always enjoy reading his opinions because it seems like he tries to drill down and get like, here's what's really going on for a layman who might be reading this.
Absolutely.
So we're going to turn now to the candy that I teased earlier. And although I will say one more thing about the Sixth Circuit. So I read a lot of course, circuit opinions randomly from all over the country. And Sixth Circuit is always, I like opening their opinions because it's less pages than a lot of others. But then I realized that's because they just have like 10-point font or whatever it is, Times New Roman shoved all into a page. So of course you end up, 20 pages is kind of long in the Sixth Circuit. Ninth Circuit, it's a breeze because it's kind of more a little book format.
Yeah.
Anyway, I just got to get that off my chest. The Fifth Circuit has it down, by the way.
Yeah, we're not going to win any awards for typography or formatting, so don't tell Mr. Butterick.
But you're not the First Circuit, so with the Courier font. So I'll give you that.
That is brutal.
Yeah, every time. So this is a case where there was I didn't really read it for the merits at all. I didn't go back and read the earlier opinions, but it's about basically the water in Flint and the ongoing litigation about the badness of the water in Flint. Am I right, Sean, or is that?
Well, no, it's Benton Harbor, but it's the same issue. So there.
Okay.
Flint took a lot of the news, a lot of the press on this. Benton Harbor had similar issues, but it's in a different region of the state. So it's not directly related. It's philosophically related.
Wow.
Yeah.
Yeah, I saw Benton Harbor and I just flipped it into my mind as Flint, but you're right. I'm sure the people there were not happy about their water. So that's what the substance of the case is about. But there's a denial of a petition for rehearing en banc, right, which is very normal. And then there are concurrences to the denial, and then dissentals, as they're sometimes called, which I have mixed views about that word that I've expressed before, but we'll just call them dissentals for now, on the denial. And a lot of what's being talked about is not the actual substance of the case and the water and the lawsuits about the water, but whether you should even have dissents from denials en banc or separate opinions. And then things get kind of weird. Do you guys want to take the lead on saying what happened here?
Yeah, I'm going to let David dive in more on the substance. I just want to kind of add on to your teeing it up on that. There are three written opinions to the denial of the en banc order. So there is a concurrence by Judge Moore, there is a dissent by Judge Larson, and there is a dissent by Judge Radler. Now, Judge Larson's dissent and a lot of Judge Moore's do hit the merits of the case and why the panel was right or wrong and what they should do. But frankly, and with all due respect to Judge Larson, I mostly glossed over her opinion because the real interest here is in sort of this fight between Judge Moore and Judge Radler about whether dissents to denials of en banc should be published. And Judge Moore keeps hers mostly to her opening paragraph and a footnote. Judge Radler offers, I believe, like 6 pages, maybe slightly less, defending these dissents. And, it's really interesting beyond the merits, just about sort of the propriety of this conversation at the en banc stage. So I'll let David jump in there.
Yeah, it's very curious. You sort of wonder how all this came about. It's a footnote at the very end of Judge Moore's opinion where she, in just one sentence and then a wall of citations saying, hey, I point out the utility or benefit of all these separate statements when we're denying a request for rehearing en banc. And so it's sort of a curious throwaway, and I question why Judge Moore would go out of her way to drop that kind of footnote. But and so I think Judge Radler was correct or correct to respond to it and say, well, wait a second, these are very important. They serve a great benefit both to our bench, our other colleagues, the bar, and especially the U.S. Supreme Court. And he, I think, very methodically goes through and cites. He brings a lot of evidence to support each one of these assertions. And so it clearly these separate statements add value to the jurisprudence. They're there for people like us, litigants, looking for reading tea leaves on, hey, what could we have done better if we were in their position? What should we do differently next time in terms of bringing a case like this? Or if you're looking ahead to the next stage, to the Supreme Court, what should we be focusing on? Who can we be using as a toehold to get into the U.S. Supreme Court? I think that last point is really, if I had to guess, I don't know this for a fact, and I don't want to, this is just a guess, my opinion, I think that's the impetus for Judge Moore's consternation, is I think she's probably frustrated by the amount of the separate writings and the utility or the benefit that they're having in terms of maybe the rate of reversal. I don't know what the rate of reversal is for her decisions, but just the attention that her and her colleagues who seem to be on the losing end of these cases get. But my response to that would be, look, this is the game that you're playing. You should be able to take respectful criticism of your work. This is part of the process, the same as every district court judge from Maine to California doesn't like to see their decisions appealed and doesn't like to read the briefs on appeal, I'm sure, but that's part of the process, and she needs to be able to tolerate that if that's what's providing the impetus for that footnote, although I don't know for sure.
And a little bit of context for that too, just for people who aren't intimately familiar with every jurist on the Sixth Circuit. Judge Moore is I think this is a fair characterization. Very left leaning, not sort of the textualist, originalist mold, and I think she sees the Supreme Court as a antagonist a little bit to her judicial philosophy. So everything that a en banc dissental or dissent can do to put an opinion on the Supreme Court's radar, I think she sees as a little bit of an additional nudge to get her reversed. And whether or not that's about her ego getting reversed, which we're not saying that, or it's about her thinking her opinion is correct and she's doing the right things with the law, and quote unquote activists above her will, conservative activists above her will be reversing it based on conservative principles, not the law. I think that's sort of her concern.
And so in that footnote, so this is footnote 2 of her concurrence, she kind of lays out this there. I think you guys are broadly correct in how you said what her concerns probably are. But it's interesting, she cites this opinion from Judge William Pryor, who is, of course, seen as a very conservative judge. And he has essentially, now I haven't gone back. It's not an opinion. It's a law review article he wrote a number of years ago now about judicial modesty and how you shouldn't be writing too many separate opinions like this. And so she's using his words to try to buff up this argument, which, I got to say, if you step outside the current Supreme Court and, the current dynamic, it's a very ideologically neutral argument, right? That we should have less of these dissentals, or we should have more of these dissentals, or whatever. So perhaps the impetus in 2025 for a judge doing this is based on the current Supreme Court, based on the current judiciary. But it's kind of a neutral argument. And her argument is that, on its face, it's a neutral argument. And her argument is that by having a dissental, so a dissent from denial of en banc, what you're doing is you're kind of weighing in as a judge who is not on the original panel, who thinks that the full en banc court should take this case. And that is a little bit of an extraordinary move, right? We should be very, I think most judges would say in the circuit courts of appeals, that we should be very limited on how many cases we take en banc. Now, you can argue that's a bad view or a good view, but that's often the view that they have. And so by having a dissent, like what are you serving here? And the answer, of course, as you were saying, David, is what you're serving. The other argument is that you're adding to the conversation, you're adding to the jurisprudence. Maybe you're flagging something for the Supreme Court, and from an ideologically neutral standpoint, maybe that's a good thing, as it further informs the Supreme Court. I gotta say, it does seem to help with Supreme Court cases being granted, where cases being granted at the Supreme Court. So they can see what they're doing. They understand the stakes here. But I got to say, if every case that where there was a random en banc petition filed, you had just a few dissentals with judges who just like the sound of their own voice and throw it in there. I don't think that serves a lot either. And these are all smart people. They all have smart things to say. So there's a balance there. I don't think the balance can be enforced by anything other than just, a culture. But there's probably something there to her critique of just doing this too much.
Yeah. So one other thing to add, though, is that I should have said this before. A lot of times these opinions are circulated internally, obviously before the decision is released, in an effort to persuade their colleagues who may or may not be on the fence. And so if you use this case as an example, there seems to be 2 judges that did not vote in favor of en banc that, if you're just looking at it through the lens of judicial ideology, would likely or usually side with Judge Larson. And so these dissentals are aimed to persuade those 2 judges or 3 or 4 judges who are there in the middle who are looking for those votes. And then, yes, they're ultimately published for the benefit of the bench and bar. But I think that is the first and foremost purpose of these separate writings, is to convince why we should be taking them. Now, the question is, should we be taking so many en bancs, or are we taking too many, and are they doing it for the right reason? Those, I think, are going to rise and fall on each case, and that's a separate question of whether or not this deserved to be en banced, and I don't know the answer to that. But I do think that there is some internal value, is sort of as an internal deliberative process.
So I think that's all true. I guess the counter to that I myself I don't think would make, but I think it would be reasonable is, well, sure, but can't that just be a memo they pass around to the court and then they just not publish it?
Sure, absolutely. I will say one thing too. I don't think her citation of these discussions about, respect for the decision of the original panel or the considered decision of the full court, which she cites that same prior article on, I don't think that's done purely as a philosophical matter. There are members of the current Sixth Circuit who maybe would agree with the dissent on the merits, but who have sort of this philosophical view that en banc should be rare because we shouldn't be reviewing our colleagues and we shouldn't be doing X, Y, and Z. So I think that's a pointed citation, and I think that's a pointed argument she's making, like David said, to some of these people who may be in the middle ideologically or who have particular ideological views about en banc. I will say, though, and if you'll indulge me just a couple minutes, I know we're probably going a little long, but there's a few things Judge Moore says that I don't think are all that consistent in her critiques, and that's fine. And it may just be that she was doing a bit of a kitchen sink approach to this. In her opening paragraph to her concurrence, she says, "By accumulating votes for or against the petitions articulated in the panel opinions, we cast doubt on circuit precedent, erode our faith in the panel system, and give rise to our own shadow docket." I have no idea what that means, because reasoned decisions are reasoned positions are sort of by their nature not a shadow docket. That's how a court operates. I think a lot of the big complaints about the decisions by the Supreme Court on motions are that the majority decision is without reasoning, and then we only get a dissent from Judge Kagan. But at least then we know what the court was discussing. Things like that. Second, in footnote 2, she says, unlike panel dissents and concurrences, which improve internal decision-making processes, dissent from the denial of en banc are often thinly or not so thinly veiled entreaties to the Supreme Court. They are essentially judicial petitions for certiorari. Now, this is a little strange to me. I don't know why jurists shouldn't be interested in the correct interpretation of the law. Obviously, they're not advocates in that. They don't care in particular whether Mitchell or the city of Benton Harbor wins. They're advocates for the law. And so, in the same way that, why should someone write a dissent from the panel decision? What's the value in that? I think that there is value in these dissentals, and if it's advocacy for the Supreme Court to take over and fix this, I think that's well within the judicial process to say, hey, here's the reasons I think this is both important and bad, and we should fix this because I care about the law. And then I just have one last thing, and it's she talks about particular concern about statements from dissenters who were not members of the initial panel, but merely sit as a scholar in residence providing academic criticism of the court. I think this point is particularly misplaced just because of the nature of en banc review. Rule 35 says that en banc review will not be granted unless it's necessary to secure or maintain uniformity of the court's decisions, or the proceeding involves a question of exceptional importance. These don't seem inherently like the sorts of situations where deep record knowledge is a primary concern. Panelists can read the panel briefs, can read the decision and read the cert petition and understand the legal issue. And so I'm not sure that, you need to have a bench memo at the panel stage to really understand the issues that I think would lead to an en banc dissent. So those are my critiques of the reasons she gives. I get her point. I think that Judge Radler might have the better of the argument, at least is in my opinion.
Well, I appreciate your both of your views on the matter, and also giving your knowledge of the Sixth Circuit and how the Sixth Circuit jives. But we are going to have to cease and desist with our panel opinions, whether of an en banc or a three-person variety today. But I'd like to thank you both for coming on the show and having this bit of a dive into the Sixth Circuit. The Sixth Circuit is always in our hearts, and so we will have many more Sixth Circuit opinions in the future, perhaps some with these gentlemen's names on it. So thank you guys both for coming on. But in a couple days, it'll be all Seventh Circuit, and we'll do that episode in a couple weeks for our listeners. But until then, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.